Hello everybody, today we're going to talk about what happens if USCIS doesn't decide an immigration case. Can you sue USCIS for delay? Today is Monday, July 10th, 2025, and let's take a look at this case. So this case is that there is a waiver that has not been decided after a very long time. So 601 waiver that has not been decided. So I'm going to dive into this case. I'm going to take a look at this case and the delay. So this is at the district court, the District of Columbia, and this is the plaintiff, and these are the defendants. So a lot of the cases are filed at the District of Columbia in DC, Washington DC, and then they name quite a bit of defendants in the case usually. And this is mandamus, writ for mandamus, and also Administrative Procedure Act. And let's take a look at what's going on in this case. So there is a plaintiff that is a Brazilian national, and she has a U.S. citizen father that filed a petition with the USCIS for the daughter to become a U.S. permanent resident. So the I-130 was approved in August of 2014. And then following the approval of Form I-130, the plaintiff filed Form I-601A. So, 601A is the waiver for unlawful presence waiver. Well, if you read into that, it means that this person came to the U.S., came here on somehow, maybe on a B1, B2 visa, and probably overstayed. Who knows? This complaint doesn't stay, but I'm making some assumptions. And now they had requested a waiver for the unlawful presence. So an unlawful presence waiver is 601A. And when they went to the interview at the U.S. consulate in Brazil, and during the interview they informed her they also required a I-601 application for waiver of grounds of inadmissibility. So there are we know from this case, we know there's two types of waivers. I-601A is that there's the application for unlawful presence waiver, and then the 601 is the waiver for grounds of inadmissibility. So those are the two waivers, and she filled the 601A first, and when she went to the interview, they said we need the 601 waiver. And they are bringing this action because they did not adjudicate, or they didn't give a decision on the 601 application. So with writ for mandamus, you cannot tell the government to do something your way. You're not asking for that. Basically, you're asking for them to do their job, to make a decision on that. So here, the plaintiff is asking for them to make a decision on the 601 application, which has been pending for over 2 years and 2 months. I mean, that's a really long time, at least when they were filing the case for a 601 waiver to make a decision. They did have a footnote here, is that the father filed an I-130 petition for alien relative when he was a lawful permanent resident, but then he became a U.S. citizen, he got naturalized, and then they're saying that the plaintiff is eligible under the immediate relative category. Okay. So they're saying the Congress said that you have about 180 days to make a decision, and they're saying that they're in violation of that, and they're also in violation of the Administrative Procedure Act. Let's take a look at the parties of that they're claiming that they're named. So there's the plaintiff, like I mentioned, is a citizen of Brazil and is currently residing in Brazil, and they're waiting an adjudication of the 601 waiver, not the 601A waiver, but the 601 waiver, the grounds for waiver for grounds for inadmissibility, and is the beneficiary of the Form I-130 filed by the U.S. citizen father. So basically, the I-130 allows the beneficiary, the plaintiff, to apply for an immigrant visa to become a lawful permanent resident of the U.S. and then she's an applicant of the Form 601. Like we mentioned, the application, the waiver for inadmissibility. So they always name a couple of different defendants in the lawsuit. So here's a they named defendant the U.S. Secretary of the Homeland Security, and the defendant is the acting director of USCIS, and another defendant is the Attorney General of the U.S. And they're saying for the jurisdiction, the court has jurisdiction because this is the federal mandamus action. They brought this to compel the defendants that were named to make a decision to perform these duties, statutory duties owed to the plaintiffs. And they're saying they exhausted all the administrative remedies that were possible. They repeatedly requested the defendant to make a final decision on the Form 601 application, which is the the waiver for ground for inadmissibility. And they initiated numerous inquiries with USCIS as well as through a senator. I don't see that they did anything with the ombudsman, but they did with the senator, and nothing has happened, and that they exhausted all administrative remedies, and there's no further administrative action remedies available to the plaintiff. Just a quick factual allegations they mentioned in a complaint. So the plaintiff father, like we mentioned earlier, filed an I-130 petition for alien relative. It was approved by USCIS and was sent to NVC. And then she filed a 601 application for grounds for inadmissibility. So she probably overstayed. The complaint doesn't mention what are the other inadmissibility is, because she did initially file a 601A waiver. Now, and then when she went into the for the interview, they said, no, we need a 601 as well. So they made numerous increase over the 2 years and 2 months. It's not resulted in any meaningful response, and it's beyond the 180 days, the Congress deadline. And, USCIS does publish historical averages, processing times. And so the historical average processing time for a 601 waiver is about 11.6 months, or about a year, about 12 months. And then they're suing now because, it's taken beyond the average waiting time for the 601A waiver. They're saying that it's over 2 years, has been pending over 26 months. So they're suing under APA. And then they're saying that historically, there's a historical average. You can look at the USCIS website, about 12 months for 601A in 2023. Maybe the times have gone up. The average time has gone up now, but and then they're saying that their application was pending for about 26 months, and given the defendant's lack of, they're not providing any reasons for not making the decision as to why it's taken over 2 years and 2 months. And they're saying that the defendant failed to do their job, failed in their statutory duty to adjudicate the application, and that they violated the APA. So what are they? Just a quick brief one. So they are saying a couple things, and as a result of this, everything was running smoothly, and the plaintiff had to leave for her interview in Brazil. So it looks like the plaintiff came to the U.S. somehow, maybe on a B1, B2 visa, and overstayed and didn't leave. So then they were looking for those those waivers, 601A, 601, and so they left. After the departure, the father struggled to manage administrative or operational tasks of a business. It looks like they owned some kind of a business, and she was helping out. And then without they have unreliable internet in Brazil, she cannot help father, especially with the time zone changes. It's making things worse. The father had to lay off employees, sell the trucks, and he's only the sole worker and struggling to meet under mounting debt. So what they're requesting is an order mandating a certain time to adjudicate plaintiff's application, or they're asking compel the defendants to perform their duties, do their job to adjudicate plaintiff's application immediately for that 601. And again, you can't really tell them, hey, approve the 601 or not approve it. Basically, they're asking them to make a decision because it's beyond the average time of how long it usually takes. That's published on the USCIS website. And they also asking for attorney's fees. So these are all in public domain. These are published by courts. I'm exercising my First Amendment right, for court records that are published in court records for me to read them. So anyone can see the public court records, and I, as a American, is exercising my First Amendment right for me to fully speak as to what is going on with these types of cases. Well, thank you so much for your time. If you like this, give me a thumbs up, like, subscribe, and thank you very much. Bye-bye.